Today, we will be talking about the challenges faced by the courts in Malaysia when deciding a case under the topic of jurisdiction. There are three challenges in general. 1. The determination of the forum of non-convenience. 2. The doctrine of lege alibi pendens. And 3. The existence of a foreign jurisdiction clause. Let's start with the first challenge, which concerns with the determination of the forum of non-convenience.
When considering an application for stay of proceedings based on the forum of non-convenience, the court is sometimes faced with the existence of proceedings in other jurisdictions. This matter came up for the court's consideration in the Riekenwolf. In this case, it was an in rem action involving a collision between the plaintiff's vessel, Captain Stefanos, with the defendant's vessel, the Riekenwolf. The defendant commenced proceedings in Malaysia and the plaintiff responded by suing in Singapore by arresting the Riekenwolf. Applications to stay the proceedings were filed in both jurisdictions. In Singapore, the application was dismissed at first instance, and the Assistant Registrar's decision went on appeal before Judge Belinda Ang Saw Ian. At the time of the hearing of the appeal, the Malaysian courts had dismissed the stay application before it. Put another way, subject to the outcome of the appeal lodged in that case, the Malaysian courts were going to hear the decision.
Next is the doctrine of lege alibi pendens. It is a Latin term that brings the meaning of an action on the same cause of actions which is pending at another place. There can be situations where the suits began between the same parties in more than one jurisdiction which occurred at the same time. This is a plea which can be raised by the defendant, in which, if it is successful, the court, based on their discretion, would order the plaintiff to discontinue the foreign suit, in which, if such orders were not compelled to, his claim in the forum court will be forfeited. This is also called an anti-suit injunction. One of the challenges is that, by having the court granting the anti-suit injunctions, it would result in the plaintiff pulling off his claim in the foreign court. These actions indirectly can be understood as if the foreign court is not the suitable forum to hear the case, and it might be regarded as an act of encroaching the foreign jurisdiction by showing that the foreign court would not have jurisdiction to hear the case. This clearly shows the challenges that the court will face in regard to granting the anti-suit injunction. Another challenge that the court may face in regards to the anti-suit injunction is that this matter could be used by the parties for their convenience and not to actually to argue their case. The parties might use this as a mechanism to delay the proceedings while having the matter of jurisdiction to be established.
Next is the existence of a foreign jurisdiction clause. It is usual for international commercial contracts to include agreed terms to decide which law is desired to regulate the contract to give effect to the transaction. Upon the foreign jurisdiction clause, the challenge faced by the court is to exercise its discretion on whether to oust such clause or upheld to such clause. The rationale behind the challenge is clear, since there is a need for the courts to regard commercial freedom in constructing the term that fits their best interest, and not to frustrate the parties on the agreed term prior to the dispute. In the case of Elf Petroleum against WinElf, it was held that it was not sufficient to oust the jurisdiction of Malaysian courts, despite the presence of an arbitration clause, since the courts adopted the approach in the case of Faymarn. On the other hand, the case of Sabah Gas Industries against Trans-Samudera Lines, and the case of American Express Bank Limited against Muhammad Taufik Al-Ozir held that the foreign jurisdiction clause does not prelude the Malaysian courts from exercising its discretion to hear the case, merely because of the clause, by adopting the approach in the case of the Eleutheria, by using the strong cause test, in which the court will tend to uphold the foreign jurisdiction clause, unless there is strong reason to refuse a stay.
In conclusion, Those are the three challenges which are faced by the courts in Malaysia in deciding a case concerning the matter of jurisdiction. So what do you think? Did you enjoy our presentation? I hope you do. And that's it from Group 9. Thank you.